SJC-12031, Kurt F. Pfannenstiehl v. Diane L. Pfannenstiehl.
And for the sake of clarity, would you characterize yourself after you give your name as attorney for the husband or the wife? And Mr. O'Regan, you may proceed.
Good afternoon, members of the court. Chief Justice Gantz, may it please the court. My name is Robert O'Regan. I represent Kurt Pfannenstiehl. Kurt Pfannenstiehl is the husband. I want to thank the court for accepting this case for further appellate review. It presents an important question, the gist of the question being whether trust law in the Commonwealth is consistently applied in the area of trust and estates, or whether trust law in the Commonwealth has a separate set of interpretation in divorce cases. As a result of this case, only in Massachusetts, now, a beneficiary's interest in a discretionary spendthrift trust with an open class of beneficiaries is deemed to be vested in possession. As a result of this case, only in Massachusetts, now, a trustee is deemed to be obligated to make distributions to that beneficiary under the ascertainable standard, even if, under the ascertainable standard, he doesn't meet the requirements for such a distribution. As a result of this case, only in Massachusetts, now, a beneficial interest in a discretionary spendthrift trust with an open class of beneficiaries is deemed to have a value equal to 1/11th, in this case, a fractional share of a determined net asset value of the trust, even though the terms of the trust with respect to exercise of discretion authorize the trustees to make distributions in equal or unequal shares to meet the needs as defined under the ascertainable standard.
Apart from divorce, given the standard, I'm just interested, the language of the distribution, is it your view that the trustees, or trustee, since it uses both in the same paragraph, is it your view that one or the other gets to say, well, yes, we understand that your care and comfort, for you, you need more money than you have, but so does your child, and so we're going to make a distribution to your child, but not to you? Is that okay?
I think, respectfully, Your Honor, that really depends on the facts and circumstances and the second prong of the standard, which allows the trustees to look at other sources of meeting those needs and the nature and extent of the need. And frankly, that is why, in this case and in so many trusts, the settlor of the trust vests that decision in the discretion of trustees who they trust.
Quite apart from divorce, could your client bring an action against one of the trustees if his view was, for 3 years, you have completely ignored me and I am eating in a soup kitchen while you are giving all this money to my brother?
Well, yes, and could bring an action, could
prevail.
To compel. Well, it would depend on what's going on to see if the client, if the beneficiary would prevail.
Let's assume that the facts bear that out. I'm trying to get at how much, is there an ascertainable standard that a beneficiary can enforce, or is it really discretionary on the part of the trustee?
The legal interpretation of the trust would be whether the trustee, in making that decision, abused the trustee's discretion under all aspects of the instrument. So part of the reason I said it would be factually necessary or determine the facts is how did the beneficiary get into this predicament? What debts or obligations would be paid by the distribution? Would it call into question whether or not there would be a violation of the spendthrift trust because the particular beneficiary ignored or failed to pay debts and so was thrown out? And so that is why it is a complicated factual inquiry by the trustee and in interpreting the trustees, meeting the trustees' obligations, it is an abuse of discretion standard on review, and the law is very clear that the court will not interfere with the exercise of discretion in making these decisions unless the decision by the trustee is an abuse. What it means in this case, in how it's been applied, is that until this case, Kurt Pfannenstiel's interest in this trust would not be in his probate estate, would not be in his taxable estate, would not be in his bankruptcy estate. Kurt Pfannenstiel has no control over whether, when, and how assets are managed. None of the income in the trust is taxable to him.
May I interrupt you there and ask you whether you think that the way funds were distributed from the trust up until shortly before your client filed for divorce, is that completely irrelevant to the analysis that we have to undertake?
It was completely consistent with the discretion that the instrument granted the trustees to make those distributions, and therefore it is irrelevant to the question of whether the interest of Kurt Pfannenstiel in this trust is a marital asset. The departure that we take from what the judges below did is that the question of whether this interest is or is not a divisible asset is a legal question to be determined from the four corners of the instrument. And what the appeals court did and what the trial judge did was infuse that analysis with facts that appeared to be bad. And the facts appeared to be bad because, as we say in our materials, there was a sense that the ex-wife should get some of the benefit from this wealthy family.
How does the bankruptcy court treat this kind of a situation?
My research on it has indicated that because this is a discretionary spendthrift trust and that Kurt Pfannenstiel would have no right to demand a payment, that the assets of the trust would not be looked to in a bankruptcy to satisfy debts.
At all?
At all.
What if it were exactly the same but didn't have a spendthrift provision in it? But in terms of the distributions, same thing for
Well,
bankruptcy?
the discretionary nature, I think the court in Pemberton made this clear, the discretionary nature of the trust means that since it requires an affirmative act of discretion by the trustee to make a distribution, that cuts off claims to the beneficiary, claims that an interest, that a beneficiary has an interest in the trust that may be enforced against the trustee.
Can the judge consider the fact that you have this spendthrift trust, or is it wholly irrelevant?
It may be considered, but it may not be divided.
Okay, so how may it be considered? What would be an appropriate consideration of the trust in the division of assets?
Our position is that under Chapter 208, Section 34, this interest does not qualify as part of the estate of Kurt Pfannenstiel. But it does qualify within the other parameters of the statute as an opportunity for future acquisition of income or assets. And in that context, it could be considered, but it does not, because it is not an asset, it is not a divisible asset, it could be considered in how the judge apportioned the true marital estate.
So it could be the case that a judge could have, in this case, said, okay, 95% to the wife, 5% to the husband.
Or 100% to
Or
the
even,
wife?
but let's just leave them with 5 for the moment, for the purpose of my hypothetical. And then in the future, if and when other distributions were made directly or indirectly, say another house were purchased, a car were purchased, credit cards were given, nothing in the name of, those could be looked to, or a stream of income could be looked to if in the hands of a husband, say.
Well,
Those are two different things. One is
Well, they're
saying
part-
you have a stream of income out there that will come in the future.
My
Therefore, we're
hypothetical.
going to give you the spouse 95% here because you've got this stream. I guess that's different than saying, okay, we're going to do 60, 40, 50, 50, and this stream of income shall be distributed as received.
Here's how my hypothetical was meant to work. Let me clarify. Going back to the judge in this case who thought the overall, let's say the judge said, in the circumstances, it should be 60-40. I can't quite get there because he should have a house to live in, and it's not going to be there. So if I make it here's what you get, here's what's liquid, and the rest you get as it comes down the road. Is that permissible?
Not under this trust instrument. Under this trust
Not
instrument,
making him give it to him, we're just saying if he's got it in his pocket down the road.
well, am I understanding your question to be, would an if, as, and when division be
Yes.
appropriate in this case?
Yeah.
And the answer is no. And the answer is no, because in the first instance, under the instrument itself, this interest is not an asset and not subject to division. And since it's not an asset and not subject to division, an if, as, or when received would be inappropriate, because if, as, and, or when received would theoretically apply only in the instance of an asset that hadn't been realized. Second, if you look at this instrument, which, by the way, is something the lower court judges did not do. The dissent did, but the majority in the appeals court and the trial judge did not do. Looking at the entirety of the instrument, this instrument is intended to benefit lineal descendants of Fred Pfannenstiehl, and he has the absolute right to do that. So under Your Honor's question...
But it is pretty interesting that for the first 10 years of its existence, he was only benefiting 3.
Well, actually, Your Honor, what happened, and the record bears this out, is from 2004 to 2008, there were no distributions from this trust, and the
I'm going to ask you
distributions...
that. That's correct, Chart? No
The
distributions?
distributions only occurred in the final 2 years of the marriage, and the distributions that were received were embodied in the assets that were subject to division. I'd add to finish the answer to Justice Duffley's question, the spendthrift clause would apply. There is Article 8 in this trust that that allows the settlor during his lifetime to add a spouse as a beneficiary. Now, that, I think, is a very clear indication of the settlor of this trust, that the beneficiaries of the trust are to be lineal descendants. And since the terms of the trust clearly contemplate distributions to benefit the beneficiary with the spendthrift clause, the trustees, I think, correctly interpreted that as a distribution to Kurt that would then go, if, as, and when, to a spouse, would result in a distribution to a non-beneficiary. And the quagmire this leads to is that, and by the way, the Tannen case from New Jersey really does speak to this question, is if you have an interest that isn't an asset, and you contemplate spitting some of this out and dividing it up later, it creates a very difficult problem for the trustees in exercising discretion to
What a
benefit
shame.
an intended beneficiary.
Okay,
Because how do they do it?
Let me ask you two questions. One with regard to what is lawful. Okay, would it be lawful for the judge in this case to have said, I'm going to give 95% of your client's income to the wife because...
Or asset, income or
Sorry,
assets?
income to the wife, because I know that that the husband can be rescued by the trust. Would that be lawful?
I don't think that would be consistent with 20834. I believe that
Why?
would be an abuse of discretion, because the cornerstone of a property division should be
This isn't
contribution.
property division, it's income.
It's income.
95% of the income? I misunderstood the question.
Yes, 95% of the income goes to her, and I know that may make him
It's
a pauper,
alimony,
but
something.
he can then go to the trust, and the trustees have an obligation to spare him from being a pauper by giving him money. Would that be lawful?
I would suggest that it would be an abuse of discretion by the trial judge. In part,
Because what's, I mean, it may not, I mean, I understand you view it as inequitable, but would it be unlawful? What would it violate?
well, for one thing, at the time of the divorce, there was no evidence that the trust was or could spit out that kind of income to support it. In fact, the evidence was to the contrary. At the time of the divorce, the trustees testified the balance in the trust account was about $12,000.
But that's because the trustees, the voting trustees get to tell you, go figure out what's going to go into the trust, right?
Well, that's what was said, but the record is thin on supporting that, because behind it is a drastic regulatory change, which is referred to in the record, that did materially affect the operating structure of the closely held for-profit businesses. The student loan industry was subject to new regulations that required, as was testified to, that the colleges be recapitalized, and it basically drove the assets, the asset value of the trust and the distribution of income into the ground. And so I think the evidence wouldn't support that in this case.
So you're saying it's abuse of discretion only because there isn't that much money in the trust, but if there were a lot of money in the trust, would it be an abuse of discretion?
Yes, because that still does not require the trustees to make the distributions in order to satisfy an alimony award. And in fact, the Tannen
No,
case...
he wouldn't be satisfying out of his own employment income. not out of anything the trust is doing.
Well,
From the college, the
I- I-
175,000.
I would still suggest, Your Honor, that that would be an abuse of discretion in awarding virtually all of someone's income as support, especially if the amount of all of the income didn't correlate to the determined needs of the former spouse.
There was no alimony here, right? This was just division of assets
This-
plus support?
Plus, yes, plus child support.
Well, what if it were, what if the judge did assign alimony, specific dollar amount per month or per year, plus a certain percentage as may be distributed from the trust? Would that be lawful?
And, Your Honor, that's the same question that Justice Stuffley answered, and the answer to that is still no. That
This kind of a trust is purely off limits, in your view, to any kind of distribution or order of support or alimony from probate court.
yes, because of the nature of the trust, the donor of the trust.
But a judge can take into consideration a person's inheritance, which this seems to be analogous to, at least somewhat analogous to, in deciding how much of a property settlement or how much alimony should be awarded.
I don't believe alimony would properly take into account the prospect of future inheritance. And as far as opportunity for a future inheritance under will, that could be a factor for opportunity for future assets and income, but it's still an expectancy. And, and that does not go to the assets in place at the time of the divorce, what the parties had, how they put it together. And so with respect to support, you'd also look to the terms of this instrument to see that this instrument would not allow a distribution, under the trustee's discretion, would not allow a distribution to Kurt for the purpose of paying alimony.
It wouldn't have to.
If the trust provided an automatic 10% of income, would that be considered an asset?
I believe that the court would treat that as a stream of income, and it would be proper to, in that case, there's no discretion involved, and it would be proper to consider the stream of income in however the court determined alimony or property division, because it is an enforceable, vested in possession right, as opposed to what we have in this case.
But would you agree that if we agree with you that the trust, that the way that the judge handled the trust in this case was error, that what has to happen is you go back to completely square one. Everything's on the table again.
I agree that the financial issues, because of the way the judge dealt with this trust, the property division gets vacated, there is no alimony award.
But there could be. I mean, in other words, it's open.
I believe all of the financial aspects of the case would be open for the trial judge. May I conclude by asking Your Honors to take into consideration the consequences of this decision? Because for the first time, I think anywhere in the United States, we have a Massachusetts court, Massachusetts, a leader in trust law, making dramatic changes in what is vested in possession, whether an ascertainable standard requires distributions, which, as we've stated in our materials, is not the law, and assigning an arbitrary value to that interest as if it were vested in possession, which is not supported by any law or method.
We are mindful of our responsibilities.
Thank you, Your Honor.
Ms. St. James? I'm sorry, Ms. Hirsch.
Yes, thank you, Your Honor. Good afternoon. May it please the court. My name is Jillian Hirsch, and I represent Diane Pfannenstiehl.
May I ask you a question? I'm sorry to come right out of the box, but the appeals court decision, it says it cannot be gainsaid that the substantial income distributions from the 2004 trust were woven into the fabric of the marriage. They didn't begin to 2009, and they parted ways in 2010. How is this woven into the fabric of the marriage?
That is correct, Your Honor. The distributions were only made in the last several years of the marriage. The testimony at trial, and even from Kurt himself, was that during that time, when he was receiving distributions that totaled in $800,000, that they were woven into the fabric of the marriage, that they couldn't have lived the lifestyle they did without those distributions. For 2 years. That is correct, Your Honor, and no distributions had been made prior to 2008. But that was a factor that the court took into consideration and was required to take into consideration under Section 34. This, of course, is a divorce case, and one where Kurt and the trustees of the 2004 trust took deliberate steps on the eve of Kurt's filing for divorce to erase a major component of his income and assets, to deprive the probate court judge of the ability to reach a fair financial settlement, something she was obligated to do and had the broad discretion to do under Section 34.
So is this income or is it an asset?
This is an asset. This is an asset includable in the marital estate, and that goes back more than 20 years to the Comans case, where the appeals court in Massachusetts said there was a trust with an ascertainable standard, and the wife had an interest in that trust. And the court there said that she had a present, enforceable, equitable right to those assets, to enjoy and to use those assets, and included the value of her interest in the estate.
Could we go back to the dissent in this case? And I do appreciate the dissent issuing a warning that we shouldn't get overly concerned about how this trust was administered and how the distributions were made. But the dissent is saying, let's take a cold, hard look at what the trust instrument actually says. Now, if the distributions had not been made as they were made, would you be making the same argument that you're making now about this present enforceable interest? Suppose they hadn't distributed anything. Could you be making that same argument? I mean, it does seem as if your argument is supported in part by what has actually happened on the ground, and I'm not sure that we're supposed to do that.
Your Honor, we would be making the same argument if distributions had not been made. The Comans case, there were no distributions made. And the court there said that reliance can be present even where no distributions are made, because the mere presence of the trust acts essentially as an insurance policy. So the married parties can spend their income in a way that they might not otherwise have done had the trust not been present. But even putting that aside, this issue of reliance, this issue of were the distributions coming in, where was the money coming from that the parties used during their marriage, this is just one of the many factors that the court is required to consider under Section 34.
So if the husband in this case were entitled to 10% of the interest that derived from the trust, would that be income or an asset?
If the husband were entitled, well, the court has the discretion to do one of two things. I mean, if this were a case where there were no ascertainable standard, but mandatory distributions were required to be made of a certain percentage, then still the court has an obligation in the first instance to determine, is this an asset? And where there are mandatory distributions, the courts in this Commonwealth have said, yes, that is an asset.
So the judge has some flexibility in deciding whether the income from this trust, depending on the terms of the trust, is income or an asset.
The judge would have the discretion in determining, based on that type of trust, whether the value of this beneficiary's interest in the trust is an asset.
Could the judge also consider it income?
For purposes of setting alimony?
Yes.
Yes, and the same holds true here, but the court has the discretion to make that determination. And under Section 34, in fact, the court could award alimony and make a distribution of property, or it could do one or the other.
In your brief, you say that the trustee had no choice but to make distributions to the beneficiaries with if they had needs that fall within the ascertainable standard. Where does that come from? How do I know that they had no choice? What part of the trust instrument do I look at to verify that statement?
To the ascertainable standard itself. And the way that the courts have interpreted that type of standard is that it limits the trustee's discretion, in the sense that if there is a need demonstrated by a beneficiary, that the trustees do have an obligation to make a distribution. And if we look to the Marsman case, in that case, it's outside the context of divorce. We're talking.
Well, suppose he doesn't need anything because he's got this $170,000 job at the bookstore. You know, the judge has given the house to the wife and the support obligation has been made and he doesn't need anything. So what's the obligation on the trustee in that situation?
If there has been a determination that there is no need on behalf of a beneficiary, the trustee does not need to make a distribution.
Okay, so if that's the case, how can the judge order distribution of something that isn't certain? I mean, he may or he may not need it.
The court here did not order a distribution to be made from the trust at all.
No, I get that. I misspoke. But the judge is assuming that he has a right to a distribution. And the scenario I'm proposing is that maybe he does, maybe he doesn't.
He has a right to the extent he has a need. And that's the initial inquiry here as to whether he has a present enforceable right. And this goes back to a question that was asked a little bit earlier on, whether he can bring a suit against the trustees to enforce that right if a need is demonstrated and a distribution isn't made.
But what I'm saying is, suppose he doesn't have a need. I mean, wouldn't the obligation to make a distribution depend on a need? And he may or may not have that.
It absolutely does, but that doesn't bear on the inquiry of whether or not he has a present enforceable right as a beneficiary to these assets.
Well, I thought he only had a right if he has a need according to the ascertainable standard.
That is
Right?
correct.
So your logic is circular, isn't it?
The question is, based on the language itself, the ascertainable standard, does the beneficiary have a present enforceable right to enforce against the trustees if in fact there is a need? Yes, that there would have to be a need in order to bring a lawsuit and to claim that a distribution should have been made and the trustees breached their fiduciary obligation in not bringing that right, and not making that distribution.
Well, it's another question, but I think goes to the same place about, and it may go to the value of this asset. But if the language says, you know, here's the standard, and the trustee can do this for the benefit of any or all of the beneficiaries, and you've got, well, at one point in time 11, but it's growing. Why isn't that language such that the trustees could say, well, it says any or all, and there's a big need, there may be some need here, but there's a big need over here, and so we're gonna worry about that one this year. And not Kurt Pfannenstiehl.
The trustees have a fiduciary obligation to make a determination as to each individual beneficiary's need, and they do need to take into account the class as a whole, and they can't ignore the needs of the other beneficiaries. But their discretion is limited to how much of a distribution to make, not whether or not to make a distribution if a need is in fact demonstrated.
Okay, so now back to Justice Hines' question, though. If you have to have a need, how does that equate to dividing this up? Put aside for the minute the open class, but let's just say it's a closed class of 11. How does that work out that the value therefore is 1/11 when you don't know whether there's going to be a need or you don't know, or whether or not there's going to be a need?
Whether or not there's going to be a need doesn't really come into the analysis of how to divide for valuation purposes, Kurt's interest or any other beneficiary's interest. And the fact that there may be multiple beneficiaries was something that in fact happened in the SL case. And the court said there that the wife's interest in the trust, even though there were 5 beneficiaries, was a marital asset and included her interest, the value of her interest, I should say, in the estate upon divorce. There are cases, including the Caruso case, where we have exactly the issue that we're presented with here, which is an open class of beneficiaries. And there, the trust was set up for the benefit of the husband and his issue, And there, the court included in the marital estate the value of the husband's interest. So the mere fact that there are multiple beneficiaries, or here an open class of beneficiaries, really it goes to the certainty or the ability of the court to determine with any precision the value. And this court on many occasions, and the appeals court has said, that the fact that an asset is uncertain doesn't derogate from the fact that it can be included in the marital estate. And all different types of assets whose valuation is uncertain have been included in marital estates.
If you win, how do you enforce it? You've already been denied your attempt to find him in contempt. Trustees could say, we're not going to pay anything because we know it's going to go to the wife, and we don't wish to give money to the wife. We think it's not even within the trust provisions to allow the money to go to the wife.
Your Honor, in connection with the contempt complaint below, there was no evidentiary hearing. So the court here was constrained to a record on which it determined that Diane hadn't satisfied her burden of showing by clear and convincing evidence that Kurt had intentionally violated this order. Of course, if this court affirms the amended judgment and he is ordered to make these payments and fails to do so, there will be discovery, there will be testimony, there will be an evidentiary hearing to put her in the position to be able to satisfy that burden.
He'd still have to have the ability to pay.
Yes, Your Honor.
Can the ability to pay be dependent upon what these trustees decide to do?
Absolutely not, Your Honor. The monies to make these monthly payments do not need to come from the trust. And the appeals court reversal of the contempt judgment had nothing to do with his ability or inability to pay. I'd like to point the court to the decision in the Crokin case, which is a decision from 1979 from this court, which said that the ownership of a valuable asset demonstrates the ability to pay without further inquiry as to whether payment can be enforced directly against that asset. And the law does not require an obligor to be able to enjoy an asset, such as a home or a beneficial interest in a spendthrift trust, while he neglects to pay his support obligations. In that case, there was a divorce, the husband was ordered to pay alimony, and he said he didn't have enough liquid assets to make those payments. And he was the appeals court and this court said that he had the ability to pay because he owned a home with his new wife as tenants by the entirety. And the court said it didn't matter that he couldn't sell that home to raise the capital to make these alimony payments unless his new wife consented. The fact that he owned this property showed that he had the ability to pay. And so the same would be true here. The court in Crokin said it was up to the husband to use his ingenuity to come up with the money.
Not the same, because you can get a mortgage on your home and use the equity to liquefy that value, but you can't get a mortgage on the trust.
That's true, but there are other ways here in which Kurt could come up with the money. The point in that case, I think, is that it's up to the husband to come up with the money and to use his ingenuity to find ways to raise the cash. As was suggested earlier, he could use every penny of his income, of his salary as the assistant bookstore manager, and use that to make the monthly payments, and then he could go to the trust and say, I need money on which to live. He could find another source of income. The court in this case found that his job didn't require significant amounts of time and that he had time to pursue other opportunities, and so he could get a second or even a third job that brought in more money so that he could make these payments. I'd like to just for one moment, I know my time is running out, address the last point, which is the judge's consideration of the trustees and Kurt's deliberate attempts to silence this interest in deciding to reject the if and when method received here and instead to order the monthly payments. As this court has pointed out, those payments were abruptly stopped right upon the filing for divorce. They continued to the two siblings for 19 additional months. Each of the siblings received an additional in excess of $300,000 more, and the court took this all into account in deciding to order the monthly payments for fear that if she did not, no money would ever be paid to Kurt and no money would ever see its way into the hands of Diane to care for Diane's children, the party's children.
All right,
If there are no further questions, thank you, Your Honor.